Hi, everybody. I'm just going to give it like one more minute because I can see a bunch of people are hopping on right now. All right. It looks like most folks have joined, so why don't we go ahead and get started? I'm Debra D'Agostino. I'm a founding partner of the Federal Practice Group. We're a law firm in Washington, D.C., although we represent employees nationwide, overseas, wherever you are. And we specialize in representing federal employees with federal employee issues. So just obviously a whole lot of federal employment issues going on right now, and several folks seem to have similar issues. So instead of doing one-on-one consults where I feel like I'm saying the same thing over and over and over again all day, we figured we'd try this kind of forum to get information out there, explain what some options for relief could be, and then uh, answer questions. It looks like you will be able to submit questions through the chat. So I'll try to get to as many of those as I can. But so I believe that most of you here were terminated as probationers, although you may not in fact be probationers. So hopefully that's what I plan to talk about today. Hopefully that is the issue you're dealing with. And so it looks like obviously the administration terminated hundreds, thousands of employees allegedly as probationers, and they had asked in advance for agencies to identify probationers, and then to have the supervisors identify which ones they wanted to keep, and then it seems like they completely disregarded that entirely, and without your supervisor's knowledge, even never mind involvement, terminated anyone coded as a probationer, and it looks like several folks were inappropriately coded as probationers and thus have been fired without due process. And so if you are not a probationer, if you are an employee, you are entitled to due process. And what that means is you're entitled to 30 days notice. You're entitled to a reason for the termination. You're entitled to reply to that reason. Um, and so, in some, there's both procedural due process as well as substantive due process, which concerns you being given some sort of cause for the decision. So obviously, over the past few days, they've just been terminating folks with no notice and no reason, aside from what appears to be largely fake reasons. But even if there is a reason, and even if it's fake, it's still very apparent that they did not provide the procedural due process that's required under the law. So I think we're seeing kind of a few categories of folks who were misidentified as probationary employees. The one that just is killing me are the folks who were recently promoted, or who were becoming a supervisor for the first time, for example. I suspect this is going to get really wide scale with the DoD terminations happening now. But if you have completed your probationary period, right? You've been working at the agency for years. You've been getting promotions. Agencies do consider that first year after your probationary period or after your promotion to be a probationary period, but you don't lose your status as an employee. So all that means is that if you are promoted you go from a 14 to a 15, and the agency believes that your performance isn't acceptable, they can move you back down to the 14, right? They cannot remove you without any due process. So I do think that if you were considered probationary because you were promoted within the past year, or like I said, first time supervisor or something like that, um, you have obviously been denied due process. You are an employee, and you should strongly consider filing an MSPB appeal, and we'll talk about that. Um, and then I'd say that the second class of folks we're seeing are folks with prior service. Generally, there's competitive service and accepted service in the government, right? Accepted means you're accepted from competition. From a practical standpoint of what we're talking about today, if you're in the competitive service, you have to do a 1-year probationary period. If you're in the accepted service, you have to do a 2-year trial period. Why they use the term trial and probation, it's like, could we just use the same lingo? But effectively, it's the same thing. 1 year is for competitive service, 2 years for accepted service. There are some exceptions, like law enforcement do a 3-year probationary period. So there are some exceptions, but I would say for the vast majority of folks, we're looking at 1 year for competitive service and 2 years for accepted service. So what that can mean, though, is that you served it for 4 years at one agency, and now you've been at your new agency for 7 months. You should not be in a probationary period if there was no gap in service, right? You basically were working for whatever, the Army, and then you got a job at DHS, and you were reassigned from Army to DHS without any break in service. You're allowed to do what's called tack on that prior service to your current service to push you past that 1-year mark. So to be able to do that, it does have to be what's called current continuous service. So again, looking for the reassignment type situation. But if you're in that situation, I do think you have a credible argument that you're not really a probationary employee, and that you're thus entitled to due process. I think we've also seen folks who were, I guess, did have a break in service, right? So you were working for an agency, you did complete a probationary period there, you then went to go work for a contractor for 3 years, and then you came back. And what we're seeing is that there's an incredibly random mix of ways agencies process that, which is really unfortunate given the gross consequences, right? That your livelihood is at stake. You'd think they take some care to get that right. But I'd say look at your appointment SF50 for how you got to the new agency. So some agencies are doing them as a reappointment, some are doing them as an initial appointment. Some are having folks put in a trial period, and then when the SF50 or the OPF gets forwarded and they see your SF50 showing your prior service, they're running correction actions to then change your tenure. Some aren't, right? And so I do think for the folks who had a break in service and then came back to the government, that's probably the kind of murkiest situation, and that's the situation that you probably do need, an individual consultation with an attorney to look at your SF50s and try to figure out exactly what happened there. There are some other circumstances, like with direct hires. I actually have this case pending now before the U.S. Court of Appeals for the Federal Circuit, where my client had prior service, did have a break, came back, and was a direct hire. And if you're a direct hire selected off a certificate of eligibles, right, this is in the language of the regulations, then arguably you do have to do a no probationary period. But if you weren't, if you were a direct hire in some sort of accepted service type hiring authority, then I'm making the argument that you shouldn't have to serve a new probationary period. So some of these issues they're just really case specific and really sticky. And I would really advise everyone to get a hold of Ideally, your appointment SF50 and then a recent one, certainly any correction actions they ran to your tenure, you need to look at. Just saying the word tenure, that triggered my mind. So there is a box on the SF50 for tenure, right? If you are career in that box, you absolutely should not be terminated as a probationary employee. If you're career conditional, that does not necessarily mean that you can be terminated without due process. So you're career conditional for your first 3 years, but you're only a probationary employee for that first year in the competitive service or 2 years for the accepted service. So career conditional isn't kind of the driving thing. It's certainly a clue to piece it all together, but just being career conditional does not mean that you are not an employee for purposes of due process rights. Hopefully that makes sense. Um, so there are these terms in the regulations that refer to, I think current continuous service is the one that's, you know, what does that mean, right? I'm getting a lot of questions about what that means. Um, so for service to be current, it must be continuous at the point of the action under appeal and without a break of even a workday. So current means the job you have now, the job you were terminated from. Continuous means what it sounds like, right? With no breaks in service. There's also, though, some exceptions, of course, for purposes of tacking on prior service. And so that's what I was talking about. If you're going to tack on prior service onto your current service, there can be a break of up to, I believe it's 30 days, um, so long as that prior service is in the same agency and what's called in the same line of work. So clear as mud, right? Like I don't know why they made these things so convoluted, but if you went from one job in Department of Army to another job in the Department of Army, and you did take a break from service in between those two jobs, and that break is less than 30 days, that service can be tacked on to your current service to push you past your probationary period. I doubt that that's really a common thing, but it's certainly still worth looking at. As to this notion of what's the same line of work, I think that I always appreciate when there is a little bit of ambiguity built in because it gives attorneys room to argue. But I think what they're looking at is it is in the same job series? Is it a similar title? Does the PD show the same sort of work being done, right? So, I mean, I think let's use kind of normal, real language when looking at what that means. And then I think, this is sort of really unfortunate. I think one other category of folks we're seeing who were misclassified are those with veterans preference. So if you have veterans preference, then you only have to do a 1-year probationary period, regardless of whether you're in the competitive service or the accepted service. So if you're in the accepted service, and you would typically have to do a 2-year period, if you have veterans preference, you do get due process rights after that 1-year period. And so that would include if you're appointed to using a VRA authority, for example, or something like that, which is a fairly common accepted service type appointment. But anything, with the Veterans Recruitment Act or any other kind of direct hire actions, often used to get very qualified veterans into the government, you only have to do 1 year, and they use the term preference eligible. And all that means is you have veterans preference. I don't know why they can't just use the term veterans preference as opposed to switching back and forth between this language of preference eligible and having veterans preference, but they mean the same thing. And your veterans preference should also be recorded on your SF50. If it's wrong, you should have paperwork to substantiate that, right? So hopefully you've got your DD 214 to be able to show how much service you had with the military if that's inaccurate. And I'd say that for whatever reason, that does seem to be inaccurate more frequently than it should be. But if they screw that up, and if you are a veteran, preference eligible, if you will, you don't have to do 2 years, even if you're in an accepted service appointment. So I think those are kind of the biggest categories of screw ups we've seen. And so the big reason this matters is, like I said, because if you're an employee, you have due process rights, and they did not provide anyone with adequate due process under the law in this situation that occurred over these last several days. So what that means effectively is that you've been denied due process, and it's the Supreme Court that held that federal employees have a property interest in their job, right? And you cannot be deprived of your property in this country under the Constitution without due process. So this notion that you are entitled to due process is deeply, deeply baked into decades and decades of law from the Supreme Court, right? I mean, this is not a premise that I think this administration could get rid of if obviously they want to, but I cannot see them having success with that because this is so baked in. That being said, I do think there's what the contours of procedural due process are could be open to debate. But I think in the case of all of you folks who were terminated with no notice whatsoever and with some generic cut and paste reason that applied to everybody, that cannot possibly be argued to be appropriate due process under the law. So I'd say the most obvious path to get your job back in that circumstance is to file an MSPB appeal. The Merit Systems Protection Board is an independent agency. They have a board of 3 members. It's supposed to be 2 from one political party and 1 from the other. And I don't know if you heard in the news lately, President Trump did fire board member Kathy Harris. She did go to court with that. She did get her job back so far anyway. But regardless of whether or not there is a board, so even if Trump came in and fired the whole board, the judges who adjudicate these cases are still going to be adjudicating these cases. So I have gotten questions of, well, can the board even decide cases if there's only 1, 2, or no board members? And the answer is yes. And we know this because this happened before. The first time Trump was in office, he did not appoint board members. The board had no quorum. They cannot decide appeals of the judges' decisions without having a board and without the board having quorum. But the judges across the country can still adjudicate these cases. So they have an e-file system. You can file an appeal through that system. This is certainly work we do. We represent people in filing these appeals all the time. I think that what we would want to do would be to, in that initial appeal filing, spell out how you are an employee and state that you've been denied due process. And I don't exactly know what the judges are doing with these cases quite yet. But typically, if there's an allegation of a due process violation that appears very obvious, what the judge would do would be to issue an order to show cause to the agency to establish that they did provide the employee with due process, right? They're not going to be able to show that here. And so that should be an automatic reversal of that termination decision. What that's supposed to mean is that you get your job back with back pay. I don't think we know exactly what this administration is ever going to do, but there are cases where instead of actually putting you back to work, they put you on administrative leave and then give you due process and essentially re-terminate you. And that is something we do see frequently in cases where a federal employee did commit misconduct, right? I mean, I don't have a great argument that they didn't, right? They were charged with misconduct. It looks like they did it. The agency denied them due process in removing them. We filed an appeal alleging a due process violation. They were reinstated, but then the agency, instead of actually putting them back to work, did it the right way. So they would issue a notice. They would say, here's the reason, you have the right to reply, and do all of those things that we would normally expect to see in this kind of circumstance, and re-terminate that person. Uh, I don't anticipate that happening here because there was no basis for your terminations. So to the extent that they have to identify some sort of cause, either misconduct or performance, it doesn't seem in the vast majority of cases they're going to be able to do that. So while typically in cases where our best argument is a due process violation, we're nervous about it happening again. In this particular scenario, that seems unlikely just because they don't have evidence of misconduct, or based on what I'm hearing broadly, actual evidence of poor performance. So I would anticipate that would mean that they would have to reinstate you to duty. Like I said, I can't guarantee that they wouldn't try to terminate you again, but they would have to give you due process to be able to do that. So I really do think that's the best bet. And obviously right now we're in an extraordinary time. Traditionally, the MSPB is the most efficient body we've got, right? I mean, I don't know if any of you have filed EEO complaints before, but it's, literally like 5 years later, we're getting it resolved. With an MSPB appeal, the judges are to adjudicate these cases within 120 days, and the vast majority of times they do that. So what we traditionally see is that we file an appeal, and within 2, 3, 4 days, the judge is assigned to the case and it's moving. Obviously, right now they're getting bombarded with volume. I do believe the paralegals, little birdie told me anyway, are sorting through to find this sort of case, this sort of obvious due process violation, and putting that at the top of the pile just because it should be easy to get rid of. So if they can adjudicate it within a week, I think they're going to try to do that for you, and get these quickly moved in and out. There's certainly could be a chance that we're going to have to write a brief arguing how you do meet the definition of employee, right? Especially in those cases where we're talking about having to look at tacking on prior service, or some mix of accepted service and then competitive service and then accepted service, and what does that mean? So I mean, there are certainly situations where I do think we might end up having to do a legal brief, provide evidence, provide your SF50s, that sort of thing, to show that you are an employee. But in the case of the folks, for example, who are considered a probationer solely because you got a promotion, I mean, to me, that one should not require a brief. They might make us do it, but it should be a situation where we put in the paperwork showing that this was just a complete screw up, and you get your job back. So, and the MSPB does have regional offices across the country. And someone is going to have a place to file no matter where you're located. I've heard the DC, the Washington regional office of the MSPB is slammed right now, and I am 100% sure that that's true. But I do still think they are going to try to get these adjudicated pretty quickly, especially given what's at stake. Other options possibly available do include the Office of Special Counsel, or OSC. There has been a class complaint filed at OSC through the group Democracy Freedom, which we're working with as well. The premise is that every one of you probationers was terminated for a false reason, right? I mean, told your performance wasn't sufficient to continue your employment, or whatever that language is that was repeated over and over in all these letters. There isn't, there's never been a class action brought at OSC before. Trump has fired the special counsel, Hampton Dellinger. He did also, like Kathy Harris, file for TRO in court. The lower court did say he gets his job back. The administration has taken that now to the Supreme Court, where it's sitting. I don't know if we know if the Supreme Court's going to actually rule on the substance of it, or um, get out of it from saying this, this shouldn't even be here because it's supposed to be resolved at the lower court level. The administration's kind of skipping straight to the Supremes, which is not normally permitted. But in any event, just given all that, I do feel like there's several of us who are a little apprehensive of OSC sticking its neck out to say that the thousands and thousands of people who were fired need to, get back on the books, right? I hope they do. I mean, it would be great. Ideally, they do exert their authority that way, but we'll just have to see what happens with that. The theory is that it's just a prohibited personnel practice, right? And so the Office of Special Counsel does have this kind of catch-all provision for prohibited personnel practices. And they will investigate them and prosecute them where appropriate. They are not known for moving quickly. They're probably the exact opposite. They've historically been underfunded, understaffed. They've lost a substantial number of their staff in recent weeks. So I don't know if on an individual basis they're going to be the most expedient place to get to for relief. But especially for those probationers who really are probationers, and the best argument has to do with being terminated for a false reason. I do think a B12 type complaint with OSC is at least something to put in, something to give you some leverage. And so what we sue the government, right? I mean, every case we have is David versus Goliath, and we're on the wrong side of that, right? So what we're constantly trying to do is to figure out how to get leverage so that the government has to talk to us to try to resolve a problem. So even if it looks like, they're really, you don't have an MSPB appeal because you're probably not an actual employee. I do think it makes sense to file an OSC complaint, file an administrative grievance even. All agencies have administrative grievance procedures. In normal times, I would almost never recommend anyone avail themselves of those procedures because it's usually a fairly toothless process. A grievance through a union comes with it the threat of arbitration, some third party neutral looking in on what happened. An administrative grievance does not come with that. An administrative grievance is typically a pure chain of command. And so because there's no judge, there's no arbitrator, there's no third party coming to look in on what happened, it's usually does not give a whole lot of leverage. In this situation, though, I do think, especially in situations where your supervisors are really unhappy that you've been terminated because you have been either there for years and performing at an outstanding level, or you're fairly new and still contributing and still very needed. The supervisors should have the authority to grant those administrative grievances and bring you back. I don't know how many will be willing to do that. I don't know even if your supervisors were willing to do that, if upper management will let that happen. But again, I do think it's an avenue potentially for relief that gives you leverage. It's also not one that comes as an exclusive remedy, right? So you can file a complaint with OSC and an administrative grievance. You don't have to pick. So, I mean, I wish there were a, sort of a cleaner way to get there, but I'd say one other avenue would be an EEO complaint. It seems that with this sort of mass termination that's going to be a tough sell. I mean, I think if for whatever reason at your agency it turned out only people who requested accommodations, for example, got terminated, that's a viable argument. Or something along those lines. But I think if you're at an agency where, every single person got terminated who was a probationer, an EO claim is going to be a tough hill to climb. It's It is though, it is something that gives you leverage. So if you really think you don't have any other options, I wouldn't say don't take that option, um, because it is a way to get the agency having to talk to you about resolving that. But I do think for most of you on this call, based on the info that we saw on your contact sheets and emails you sent and those sorts of things, hopefully we do have a viable path to the MSPB. And like I said, I do think that that's hopefully a pretty straightforward um, avenue for relief. If you do, so there are some election of remedies issues. If you do file at the MSPB, you're not supposed to also be able to file an EO complaint. And then a grievance through the union is also a remedy that if you elect that, you cannot elect other remedies. So so there are some election of remedies issues that can come up. With a removal, though, with a termination, the vast majority of times the MSPB is where we want to be, if for no other reason, because they're actually going to resolve the situation quickly and expediently versus over the course of, years even, like some of these other bodies would. I do know that, some of these unions are, obviously they're they're doing all they can. And some are just stretched to the point of too thin to be able to help individuals. Um, certainly if you have an option to file a grievance through the union and your union is willing to say that they'll take that to arbitration, that's oftentimes a great option. I do think if you have the option, though, in this particular scenario to go to the MSPB, it probably makes sense to do that instead of going through the union grievance procedure, just because at the MSPB, like I said, it should be a pretty black and white assessment. Once you're sure you are actually an employee with the status to be able to file there. I know there's been a whole bunch of questions. Let me see if I can figure out how to see them. Step number one, find them. And then get to the top of them. All right, so one question: if you get a job soon after the final day of, is there any point in pursuing legal action? So if you got another job and you do not want your job back, then I'd say that in normal times, people would file just to be able to get a clean record, so that they didn't have a termination on their record. Right now, I think that no employer is going to look sideways at you because you were terminated in February 2025, right? I mean, I just can't imagine that that's considered a stain on your record the way it normally would be. If you do get another job, then your back pay is cut, right? So if you were making $75,000 with your government job and now you're making $100,000, you're not going to get any back pay. If, however, you were making $100,000 with the government and now you're making $75,000, then you could get back pay. You might decide that's, you're just going to take that lump of money and be done with them and then resign. But that should be your choice to be able to do that. All right, someone else said they have 4 years of service with then a 7-year break. So I think for folks in that situation, like I said, I think that's the trickiest. And I would say that in that situation, do try to get an actual individual consultation with an attorney to look at your documents. But chances are that when you joined the new agency, they did that as an initial appointment. If that was an initial appointment from a certificate of eligibles, my hunch is they're going to say you do have to serve another probationary period. It is going to be really circumstantial, though. So I think that's, I'd say the other thing is if you put in an MSPB appeal and the MSPB says, nope, you're actually a probationer. I don't know that too much is lost, right? I mean, I don't know if you're making that sort of gamble or taking that sort of gamble on that kind of argument that it makes sense to hire an attorney and do all of those things for that. But you can always throw in yourself and see what happens with it. But I'd say consult with an attorney in that sort of tricky circumstance. All right, and then I see some questions about if you were, it looks like transferred or appointed. So the first SF50 you have from your new agency will show the action that they use to get you there, and will come with the legal authority. So I've seen reassignment, reappointment, as well as initial appointment. I think that if you're categorized as a reassignment or reappointment, you're likely to have a better leg to stand on than if it's done as an initial appointment from the get-go. But if there was no break in service, then the question is, can we tack on that prior service? And I think there's a lot of circumstances where the answer is going to be yes, we can. And so even if the new agency did it as an initial appointment, we might be able to argue that that was erroneous and it should have been done as a reassignment or a reappointment. Also, look at your SF50s, but sometimes you are appointed as a career appointment, and sometimes it's a career conditional employment. So I do think if it was a career appointment, but then they're trying to say you're a probationer, that's double talk, right? So I think in those cases where you see those inconsistencies in your records, also, I mean, consult with an attorney. I wish I could say this sort of one size fits all golden rule, but there's so much messiness that they created with these situations. And I just love, as much as I love to blame HR for so many things, I actually do think in this particular situation, the regulations just, they're not as clear as they should be. And there isn't good, consistent guidance from OPM on what's supposed to happen, which really never mattered much before because nothing like this happened before. I think this whole circumstance is just, put a light on what a train wreck that has been. Hopefully they'll fix it, but I don't even know if they'll be functioning. So I guess we'll have to see. What's the time period that constitutes as a break in service? There are circumstances where you can have up to a 30-day break in service. If it's going to be continuous, though, you can't have the break. So I think if you're 30 days or less, it's worth a second look to see if what situation you or what bucket you kind of fall into. If it's more than 30 days, that, like I said, that's going to be a tougher argument to make. But there are circumstances where, so I've seen some circumstances where there was like a period of LWOP, or there was a something aside from like a resignation or termination, and then a complete reemployment later on, right? So if there's any kind of gray area in that break in service, if you were permitted to use a few weeks of leave, even if, again, it can be situational. I think if you were on extended LWOP, there's a very good argument that you were employed the entire time. There can be a point after 6 months where you stop accruing time toward retirement. But I think if you were on extended LWOP, we could still make a credible argument that you were employed that whole time, even if, like I said, you would stop accruing time toward retirement. When changing agencies with continuous service, if the offer letter indicates you must serve any probation, does that negate the due process argument? I think no. I mean, I think there's going to be enough examples where it's just very apparent HR screwed up, that uh, eh, we could get through that. I also think a lot of times when they make the offer, they don't have your OPF, right? So a lot of times when you're initially onboarded, it's done as an initial appointment. And then, 3 weeks later, or whatever, your OPF shows up, and then HR looks at it and they say, oh, this person has prior service. And they change your service computation date, and they run correction actions to fix all of this stuff. It looks like in some cases they do run correction actions to show you're not a probationer. Um, Sometimes they do like the mishmash, right? It's like they change your service computation date, but then they still make you a probationer. So I do think with that kind of situation, it's worth trying in this circumstance. Um, it's I like I said, I feel like I've said this 10 times already, but I mean, I do feel like what we're going to want to do is make it as plain as we can, right? As short and sweet as we can, literally highlighting boxes on your SF50, to show, to show the trajectory and show how under the law you fit into either the rule for the competitive or accepted service to get past that. Let me just scroll down here. I know there's a bunch more questions. What's the best way or documentation to prove same line of work? Like I said, I think if you're in the same series or have the same job functions on the position description, or even on your performance plan, right? If your performance objectives are describing the same sort of work, I think that's a credible argument. I also think go broad on that. So for example, if someone, I'm just thinking of an attorney, right? I mean, if I was working at Department of Labor doing collective bargaining regulations or something, right? And then I went to go work for Department of Transportation, and I was still doing regulations, but it had to do with, I don't know, railroad safety or something, right? So very different sort of substantively. There's still a credible argument that I was an attorney doing regulatory work. And so I think that that's the kind of argument we'd want to make, is that it's really a similar line of work. I mean, if I was working at Department of Labor as a I don't know, doing what, right? I don't know, program management, right? I was crunching data or something like that. Um, and then in my spare time, I was getting a master's degree in who knows what. And then I go work at Department of Transportation, and I'm doing something technical, right? An engineering job or something like that. That's, those are not going to be similar lines of work, same line of work. But I think for a lot of these, um, you know, uh, it's going to be kind of a reasonable person standard that gets applied. Um, does status as a Schedule F employee change anything? So Schedule F is, well, I guess now it's called Schedule PC of all things. I can't remember what the C is supposed to stand for. It's like schedule policy and who knows what, but I think they just thought it would be cute to call it Schedule PC. But so this whole thing is taking folks who do any kind of policy, developing regulations, rules, any of those sorts of things, certainly anyone who works in something called the Office of Policy for an agency, removing those people from the competitive service and putting them in the accepted service, with the added bonus of also stripping away all the rights that they would have if they were just normal accepted service employees. So it doesn't just move these folks into the accepted service, it also strips away any right to appeal to the MSPB, which for most folks after 2 years in the accepted service, you can appeal to the MSPB. So this has not actually been effectuated yet. There's been a lawsuit, probably a few filed. It looks like they were targeting, I want to say April, for making folks Schedule F. So, I mean, I do think that if you do work in an office of policy, and you anticipate you're likely to get terminated in a few months anyway, and you're going to have to be dealing with a very complicated legal challenge. I mean, I certainly can't blame anyone who just wants to walk away from government service right now. I mean, life's short. You only get one of them. Um, and your mental health, your physical health are everything. So I do think there is a big question as to whether or not Schedule F will be held to be legal. And I think the part of it that's exceptional is stripping away the rights that are afforded to regular accepted service employees. So I do suspect part of it could be held legal. In other words, President Trump could accept certain positions from the competitive service, but the stripping away of due process is going to be the part we'll have to that I'm sure will end up getting resolved in the courts. Um, uh, Question about whether you can file your own appeal and join one of the class actions. Um, so this is such an interesting issue because there's no provision whatsoever that allows you to file a class action at OSC. So it's not like we have some body of law that says this is an election of remedies that precludes some other option. Typically with a termination, the prohibited personnel practice that you're alleging is whistleblower retaliation. And in that circumstance, you have to choose between an OSC complaint and an MSPB appeal. However, whistleblower retaliation is not a B12 complaint. So with whistleblower retaliation claims come the opportunity to get what's called an individual right of action before the MSPB. So basically, if you were terminated because of whistleblower retaliation, you can either file a complaint with OSC or the MSPB. If you file with OSC and they don't pursue it all the way through corrective action, at a point you're issued a notice that allows you to take your own case to the MSPB. So because you could end up at the MSPB in both circumstances, just to avoid giving you two bites at the apple, you've got to pick. A B12, though, does not come with an individual right of action. So I don't see how they could say it's an election of remedies to join a class before OSC and then file your own individual MSPB appeal. There is a provision at the MSPB that allows for class complaints, which I think can make sense in certain circumstances. So for example, I think it could make sense to do something like a class action of folks who have veterans preference, who have 1 year of service or whatever, 14 months of service, and were terminated as probationary employees. That's the same legal issue. And I wouldn't necessarily call that a class action. I would probably call it a collective action. Basically, we're gonna ask for these appeals to be collected and adjudicated together simultaneously. And that's something that we can do at the MSPB. A lot of times, though, I mean, to be candid, class actions are oftentimes more trouble than they're worth for any individual person. Because you end up getting, sort of caught in issues like, do you all have the same legal issue, right? And, some of you might be accepted, some are competitive service. Those are two different legal issues likely. And so trying to mush those two things together in a class action could be, more, like I said, more trouble than it's worth. I think for these MSPB appeals, individual, per employee appeals, especially for those folks who have a very clear argument that you're an employee, are probably your best bet. And I don't know that it really advantages you to connect yourself to anyone else. As I'd say that from the perspective of an attorney, I mean, my interest is always my client's interests first, right? So I'm more concerned about what happens to you, my client, than to to what happens more broadly. I mean, my ethical obligations are to you as a client. And so if there was some reason that I thought it would make more sense to tag yourself onto a class and to bring something individually, that would be something we could discuss. But most times it makes sense to be a little selfish and do it yourself and get your own personal remedy versus getting potentially bogged down with other people's messy issues. Um, I mean, again, I can't sort of blanket say that, but that's yeah. All right. Bunch of questions about, do I need a lawyer to do this? Should I get a lawyer? I'll say you don't need an attorney. I do think I, it's not a process that is necessarily intuitive. I'll put it that way. I think sometimes like with the EO complaint process, especially at the informal stage, it's kind of designed to be pursued through someone without representation. You can have representation, but they try to make it kind of user friendly. The MSPB is certainly not a user friendly entity. So like I said, I would think that, for example, what my firm could offer you folks would be representation for filing that MSPB appeal, and then doing potentially, like I said, a brief arguing that you do have due process rights and that you were denied due process rights. I suspect, quite frankly, we're going to be doing a lot of this as kind of cut and paste situations because we're probably going to be putting people into buckets and figuring out who's got the same argument to be made. Obviously, you'll have different, dates of service and work at different agencies and all of those things. But, I do think will kind of be able to do it to scale, which will make it more efficient and less expensive. We typically do this work on an hourly basis, and attorney's fees are part of the relief that you're entitled to with the MSPB. So the way that works is if we prevail, we put in a petition to have the government pay attorney's fees. They then pay us, and then we turn around and reimburse you what you paid into us. So my usual hourly rate is $5.50 an hour. I do have several attorneys here with rates much lower than that. We also do have paralegals with rates lower than the associate rates. I do anticipate we'll probably be relying on paralegals a lot for this because, like I said, I do think we're going to try to do this very, very efficiently, get these in very quickly. And we're not going to be reinventing the wheel. I mean, we're going to be we're going to be applying a law that's could be more plainly written, but to your circumstance, and the argument's going to be we're denied due process. So it's not like we're going to be trying to figure out, did you do the misconduct or not, or the Douglas factors, or all those messy things that normally go into MSPB appeals that end up, taking a lot of attorney time and costing a lot of money. There's just to kind of give a warning, there is a premise that if the government does the right thing basically on its own accord, they can say that they shouldn't have to pay fees. I don't see this administration fixing anything on their own good accord. I don't see them saying, oh no, we denied you due process, we didn't mean that, we screwed up. That does sometimes happen in normal times. I can't see that that's what's going to happen here. They might say, oh yeah, shoot, you're definitely an employee. You've been working for whatever for 12 years. And just because you got a promotion last year does not mean we can fire you without any due process. And so they might see that and reinstate you on their own without, kind of going through the whole rigmarole. But, we'll have to see. Obviously the agencies are also overwhelmed. Yeah. Question about timing. So typically you have to file an MSPB appeal within 30 days of the effective date of the removal. I think we're going to be able to get some leniency on that, although I do not want to have to make that argument. I'll put it that way. So ideally, we would file this appeal within 30 days of the effective date of the termination, or even less time, quite frankly, and get that in so that it's in the hopper. There are also, I should say, there are very limited circumstances probationary employees can appeal to the MSPB even without being an employee. So if, there's just not a credible argument that you're an actual employee, you are a probationer. The MSPB appeal right you have is if you can show you were terminated for partisan political reasons. I have to say that's not something I've ever argued in my career that I can think of, but very well could be applicable now. Marital status, which I really can't think of a time when I've ever seen anyone argue that, but it's a thing. Or what are called pre-employment conditions, which I don't see that being applicable here. That would be something like in a background investigation that came up or something like that. And in that case, they are supposed to give you notice and a chance to reply and all of those things. But those are the only three very limited circumstances that probationers can appeal to the MSPB. So if you're just going to be arguing due process violation, you're going to have to show that you're an employee. I guess someone said their letter says the termination is effective March 14th, and they'll be on admin leave until then. So we do usually have to wait until the action has been affected, which normally is, so a lot of times, if someone is being terminated for misconduct or poor performance, a lot of times they'll get a letter that will say, we've decided to terminate or remove you from federal service. This is going to be effective in 10 days, whatever. And we usually have to wait for that 10 days to pass for the action to be effective, and only then can we appeal to the MSPB. So I do think that that's what we'll be looking at here. I should also, I'm seeing some questions. There are a few groups of folks who do not have MSPB appeal rights and are not going to have them in this circumstance. So for example, TSA screeners do not have MSPB appeal rights. And it's actually really funny to me, but the notion is that because TSA screeners are under the FAA's disciplinary system, they don't have any MSPB appeal rights, except that FAA employees now do have MSPB appeal rights, but somehow TSA screeners are still not with any luck. Air marshals is another, they're also under TSA. CIA employees don't have MSPB appeal rights. There are circumstances where some intelligence agency employees do. So if you are with DIA, NSA, NRO, one of the DoD intelligence agencies, if you have veterans preference, then there is a chance that you could appeal. It's going to only be if you have veterans preference, though. So, again, I think that's sticky enough that you'd probably want to consult with an attorney. FPI employees typically do not have MSPB appeal rights. GAO employees, National Guard Tech employees actually were recently given MSPB appeal rights. But so there are some categories of folks who are never going to have MSPB appeal rights. There's also the VA, which could be its own hour-long presentation. So the VA, if you are a Title V employee, you should have MSPB appeal rights. If you are Title 38, you would not. And so Title 38 would be people involved in patient care. There's also hybrid employees at the VA who do have appeal rights. So I know it's not many people, but if you fall into that service or sort of into that bucket, you should have MSPB appeal rights. All right, I see we are at 3:59 now. So I guess I wish I could get to more of these questions, but I am happy to do one-on-one consults or offer up any of my partners for one-on-one consults with any of you. we can also certainly do representation agreements with you folks. So if you do want to retain us to do an MSPB appeal, we could certainly get that set up. We can do that paperwork by email with electronic signature. Um, I do feel like for the less complicated cases, like I said, I think we're going to try to do these as efficiently as we can. For those cases that are more complicated, we probably will need to do an actual consultation with you to figure out, um, if we've got a credible argument that you're an employee, and if not, what alternative options could be. Um, but I'm so sorry you're all in this circumstance. It's yeah, I mean it's really unfortunate what's going on right now, and I think at the core of it, the fact or the notion that any of you could be fired just without notice and somehow that doesn't matter is kind of the most gross part of it. I mean, I obviously every one of you were contributing um, to our country, right? Doing whatever it is you were doing for our country, be it, as a scientist in public safety, law enforcement, whatever you guys were doing. I'm so sorry that you've been treated this way, especially those of you who do have significant service on behalf of our country. This should not have happened this way, and it's certainly not, they could have taken a few weeks to get this right instead of doing it in this completely rushed, incredibly messy way, completely derailing people's lives as a consequence of their sloppiness. That certainly not should be how this happened, um, but here we are. So like I said, happy to either set up additional consultations with you folks or have you set up with consultations with other attorneys at the firm. Happy also to just get you representation paperwork. We'll probably have you send us an SF50, take a quick look at it, make sure it all checks out, and then we can go from there. But I do anticipate that we're not talking about probably more than an hour of work, maybe 2 hours if we've got to write a brief, but we're certainly not talking about what would typically be entailed with an MSPB appeal. So hopefully we can do this for you fairly efficiently at a fairly low cost, and hopefully get you your jobs back. All right, I know I went a couple minutes over. But thank you all for joining us.